Hello there, everybody, and welcome back to the Law and Crime Network and Law and Crime on Sirius XM Radio, channel 109. I'm your host, Jesse Weber. I'm so happy you're joining us because we have a very bizarre but interesting case that we're covering right now. It's the that's right, Reverend Shaun Harrison case out of Massachusetts. A Boston pastor is currently on trial for numerous crimes, including allegedly attempting to murder a high school student by shooting him execution style in the back of the head in 2015. According to Luis Rodriguez, the victim, Mr. Harrison, who was the dean in his school, befriended him, and he wanted him to sell drugs for him. That's right. It's alleged that Reverend Harrison is actually involved in the illicit drug trade, and he had Mr. Rodriguez sell marijuana for him. According to the prosecution, the two had a dispute over decreased weed sales. And what did Mr. Harrison do? He tried to take out Mr. Rodriguez. We saw the testimony of Mr. Rodriguez last week. The victim himself took the stand and said Harrison tried to kill him. Well, we're live in the courtroom right now. The lead investigator is on the stand, and this lead investigator is being grilled under cross-examination about why certain items of clothing were not tested in connection with this shooting. Let's go live into the courtroom. For anybody just joining us here on Law and Crime, this is a live feed into the Shaun Harrison case out of Massachusetts, a reverend who is on trial for attempting to murder a high school student by shooting him in the back of the head execution style. This victim, this high school student, testified last week. He survived, says that Harrison tried to shoot him because they were involved in the drug trade together, and he was hired by Harrison to sell marijuana. There was decreased weed sales. Harrison got upset, tried to take him out. Let's learn what's going on right now. We have a live feed. This is the lead investigator in the case being grilled under cross-examination about how he handled this investigation. So who better to talk with about this than attorney and former FBI agent Bobby Chacon? Bobby, it's great to have you on.
Thanks for having me, Jesse. Good morning.
Bobby, what do you think about the investigation into this? It's a bizarre case about a reverend who's on trial, a 55-year-old reverend who's now on trial for the first time in his life. This lead investigator is being grilled about how he investigated and whether they tested certain items of clothing in connection with the shooting. But what do you make of the investigation in this case?
Well, we had an old axiom that, when you can't attack the facts, attack the police, or more broadly, attack the process or the system. And so I think that's what you're seeing here. You have a defense attorney who has, his client is on video. The victim knew the client and is on the video also. The victim has said, this is the guy who shot me. The facts are almost indisputable when you have a witness to the crime and you have the crime on video. So the defense attorney is using a diversionary tactic of attacking the investigation, attacking the police, he'll probably attack the crime lab if he can. And so this is one of those, if you can't attack the facts, attack the police. And that's what he's doing. He's going through this methodical process of trying to undermine or question, what was done and what was tested and how it was tested and stuff. That's because he can't really challenge much of the facts. And so, I think this is what we're seeing. It's a pretty much of a diversionary tactic to try to get the jury's attention away from, the victim's testimony from last week and the videotape of the shooting and things like that. So, this is something we've seen before. Sometimes it works. Hopefully most times it doesn't.
Well, excuse me, Bobby, I'm losing my voice in a second. But we are going to go live right now because we're talking about investigating this matter. This is the lead investigator in this case. He's being grilled under cross-examination now about questioning the victim, Luis Rodriguez. What did he learn from the eyewitness, the victim in this case? Let's learn. Let's go live. Welcome back, everybody. If you're just joining us here on the Law and Crime Network or Law and Crime on Sirius XM Radio, this is a live feed into the Reverend Shaun Harrison case, a Boston pastor who's on trial for allegedly attempting to murder a high school student named Luis Rodriguez by shooting him execution style in the back of the head in 2015. It's alleged that Mr. Harrison, this Boston pastor, was involved in the drug trade and that he hired Rodriguez to help sell marijuana for him. Apparently, allegedly, there was a dispute over decreased drug sales. Harrison wasn't too happy about that and tried to take out Rodriguez. I want to bring back in my very special guest to talk about this, attorney and former FBI agent Bobby Chacon. Bobby, what we're listening to right now is the lead investigator on the stand being grilled by the prosecution about why this case was investigated in a certain way. And that's my question for you. In your experience, and it's great that you have the double experience here, both as an attorney and as an FBI agent, if a jury hears that a case was not investigated thoroughly or even properly, is that enough for them to say not guilty?
Well, we've seen this defense strategy work on occasion. Obviously, one of the biggest cases we know is the O.J. Simpson case, where the investigation was really attacked. How the evidence was collected was attacked. So I think from the notoriety of that case, we do know that this defense tactic sometimes does work. Now, it all depends on how many mistakes were made, what mistakes were made. We've already heard this investigator saying something slipped his mind to do something. So I think the defense feels they have a little bit of a crack in there they're going to drive into and try to make this look like a shoddy investigation. I mean, they have a high bar and they know it with the eyewitness testimony basically of the victim, who basically knew the perpetrator or the accused in this case. And you have the videotape. So the defense knows it has a high bar. So it really needs to kind of start attacking the investigation. You just heard him talk about what things were submitted for analysis to the lab. If not everything was, they're going to question why everything wasn't. He's talking about descriptions of the clothing now that were on the paperwork. So, you know, the videotape isn't great. So he could start to maybe put something in the jury's mind that maybe the clothing description doesn't, what you see on the videotape doesn't match what was taken, you know, in the paperwork of the police. So you're going to see this because you're going to see this used more in this particular case because of the other evidence that already exists. The fact that you have videotape, the fact that you have a witness who is also the victim who knew the alleged perpetrator. So I think this is the type of case when you have a high bar like that for the defense that they almost have to attack the investigation because the fact, otherwise, you know, you have to go after the victim witness here in this case.
And talk about a high bar, you're talking about a reverend who's being accused of being a drug dealer and a murderer. So, of course, the investigation has to be proper, because this is not like a standard kind of defendant. This is unique. This is a unique case. Bobby, stand by. We're going to go live into the courtroom again. This is the Shaun Harrison case, a reverend who's on trial for attempted murder. This is the lead investigator in the case being grilled under cross-examination. All right, folks, that's the Shaun Harrison case out of Massachusetts, a reverend who's on trial for the attempted murder of a high school student. It's alleged that this reverend is actually was leading a double life as a drug dealer, hired this high school student to help sell drugs. They got into a dispute, and he tried to take him out. So that is a live feed. We're going to be back. We're going to have to take a quick break, and there's a lot more to analyze in the Shaun Harrison case. Stay tuned. Welcome back, everybody. If you're just joining us, welcome to the Law&Crime Network and Law&Crime on Sirius XM Radio, channel 109. I'm your host, Jesse Weber. We're covering the Shaun Harrison case out of Massachusetts. That's a live feed right there. Shaun Harrison is a reverend who is on trial for many different crimes in connection with the attempted murder of a high school student named Luis Rodriguez. Mr. Rodriguez testified earlier in this case that Mr. Harrison, according to him, tried to kill him, that he tried to shoot him execution style in the back of the head because Mr. Harrison is a drug dealer who was engaged in the illicit drug trade and wanted to and enlisted Mr. Rodriguez as his sales associate, trying to sell marijuana. And there was a dispute between the two, decrease marijuana sales, and he tried to kill Mr. Rodriguez. That's the theory that the prosecution's going with. The defense is saying this is ridiculous, that my client has never done this. He's been a reverend. He's not a drug dealer. Right now, the lead investigator is on the stand, and he is being questioned by the defense about the tactics and the methods and the procedure he used in investigating this crime. I want to bring back on Bobby Chacon, attorney and former FBI agent. Bobby, they're talking about search warrants, okay? Now, what could a lead investigator do that is improper with respect to a search warrant?
Well, one of the things is to seize something that's outside the scope of the search warrant. For example, in a search warrant, there's a specificity requirement. So you have to be very specific in what you're looking for in the search warrant. And those things are actually named in the body of the search warrant that a judge approves. And you have to only look in certain places that could contain what you're allowed to look for. You know, if you're looking for a car, you're not allowed to look in a closet, that kind of thing. So if you see, so he's probably looking at the list of items that were seized. He's looking at the search warrant, and if he sees things that are seized that weren't part of the search warrant, that goes outside the scope of the search warrant. An example like that would be improper. You're only allowed to search for certain things that the judge approves in a search warrant, and then you're only allowed to seize those things that fit those descriptions. Sometimes it's broad, sometimes it's not so broad, but that's an example of what you can do to kind of run afoul of the rules when you're executing a search warrant.
That's interesting. I'm curious to see how the defense will move towards with this lead investigator and questioning him. Let's go live again. This is the lead investigator in the Shaun Harrison case being questioned by the defense. All right, ladies and gentlemen, they're going to a break right there in the Shaun Harrison case out of Massachusetts. Welcome back to the Law and Crime Network and Law and Crime on Sirius XM Radio. I'm your host, Jesse Weber. So this is a very interesting case about a reverend who is on trial for attempted murder of a student. The Reverend Shaun Harrison, was a dean at the English high school where Mr. Rodriguez was a high school student. And according to Mr. Rodriguez, he was enlisted by Harrison to sell drugs for him, that Mr. Harrison was really living a double life as a drug dealer. And they were engaging in this back and forth, and apparently a dispute arose over decreased weed sales. And according to Rodriguez, Harrison tried to did shoot him in the back of the head, but he miraculously survived this shooting. It was captured on surveillance footage, but it's very hard to tell who is what's going on in that footage. I want to bring back in Bobby Chacon. Bobby, what did you think about the actual evidence against Harrison, including that videotape? I don't see anything on it. Did you?
Well, it's not the videotape alone. I think if they had the videotape alone, it'd be more problematic. But you have the videotape, which supplements the testimony from the victim, and the victim is on the videotape. And the thing that hurts the defendant in this case is there's only two people on that videotape. It's not a crowd of people where you can get mixed up. There's two people walking down that sidewalk. They kind of disappear at the end, but you then see the victim kind of stumble back into the main frame of the video. And so you have this video, but you have a physical human witness in the box explaining, I'm in that video, this is what's happening. And so that's why that video is powerful. If it was just a video, for example, God forbid, if that young man had not survived that attack, you'd only have the video, and the video would be much harder to explain. But when you have a witness that's in the video and can explain the context of what's happening in the video, then the video really becomes more valuable. The video becomes alive to the jury, and because you're hearing from one of the people that's actually in that video. And so I think that, the video itself, is not exactly that powerful because of it's grainy and it's dark. But when you have a participant that's in the video that can come before you and say, that's me, this is what's happening in the video, that's him, this is what he's doing, then it adds a lot more, credibility and foundation to that video.
But why should we believe Mr. Rodriguez, the victim? In one sense, they said he has experience selling marijuana. He had smoked marijuana before the shooting. So if I'm sitting on the jury and I'm like, okay, here's a guy, a high school student who's admitted to being involved in the drug trade. Then you have a defendant who's a reverend and said that he's never even been involved. He's not a drug dealer, he's a reverend who's 55 years old, first trial he's ever been on. What does the prosecution need to do, or have they done and said, you got to believe the victim here. Don't believe anything the defense is saying.
That's right, and you're absolutely right, Jesse. It's always problematic when your victim is also a co-conspirator in the crime and actually admits to some of the crimes that he's putting on to the defendant in this case. So you have to kind of resurrect that witness, because he's not only a witness in this case, he's also part of the criminal enterprise that he's alleging the defendant was running. So that's problematic. Now, the defense is going to make a lot of hay with that. They're going to say, this guy's a criminal himself. He'll lie to get out of the crimes he has committed himself. The alternative is, why would this individual put this on the Reverend? What, did he have an axe to grind? If the Reverend didn't actually shoot him, why would he put it on him? What's the motive? Now, remember, the defense doesn't have to proffer a motive. They don't have to proffer an alternative theory. They often do, but they're not required. They just have to raise a doubt as to the reasonableness of the prosecution's claim. So, it is problematic, and I think that the way a prosecutor goes is very interesting. The way the prosecutor goes resurrecting or building up that witness as to why he would be fingering basically the defendant in this case, when he's such a paragon of virtue by the defense's claims in this case. I think, at some point in this type of case, the defense may want to proffer a theory as why this defendant is lying and putting his client into this, conspiracy. But they don't have to. It's not a requirement. But the jury is going to sit there maybe and wonder, and the prosecution may bring it up and put the pressure on the defense to come up with an alternative theory as to why this witness would, put the blame on this. When that witness is saying he's in the video, wouldn't he want his own attempted murderer to go to jail? And, the defense could say, well, maybe it was another drug dealer that he's afraid of,
right?
Whatever the reason. So, it's going to be interesting how both sides handle that issue moving forward.
Well, the investigators in this case, including the lead investigator who's on the stand, believe they got the right guy, that this guy, Reverend Harrison, is a guilty party. They believe that. They think that they properly investigated this case. So they're on a break right now. When we come back, we're going to take a short break ourselves. And when we come back, we have a lot more to dissect in this case here on Law and Crime. Welcome back to the Law and Crime Network and Law and Crime on Sirius XM Radio. What we were just playing for you was crucial testimony in the Shaun Great case out of Ohio. Shaun Great is a convicted murderer, a man who was on trial. We covered it here on Law and Crime. He was on trial for the murders of two women, Elizabeth Griffith and Stacey Stanley, or Stacey Hicks, as well as the abduction and rape of a third woman who's been identified as Jane Doe. What you were just listening to was the testimony of Ed Staley, a BCI agent who discovered the decomposed bodies of these two women in that house. And remember, for anybody who followed this case, Jane Doe called 911. She escaped her captor, called 911. They came to that house, and they ultimately found these decomposed bodies in the house. Now, that jury who heard all this, they convicted Mr. Great across the board of murder, aggravated murder, I should say, kidnapping, rape. They also recommended that he be sentenced to the death penalty. What I want to talk about now is the discovery of those bodies. And I want to bring back in our special guest, attorney and former FBI agent Bobby Chacon. Bobby, you're listening to that, and in your career, I'm sure you've investigated some heinous crime scenes, some heinous kinds of events. Can you walk through with our viewers and our listeners on SiriusXM, what is it like going to a crime scene for the first time?
Well, sure. And Jesse, I ran the FBI's underwater forensic program for 19 years, and that consisted of me running the dive teams both in the New York office and later on the Los Angeles office. So we responded to a lot of bodies that had been murdered and dumped in the water, too many children to even remember. And so when you are an investigator, I testified many times, as this gentleman we just watched. I testified many times about bodies that we had recovered in advanced stages of decomposition, and different things like that. You have to, paint the picture for the jury. You walk them through the photographs. It's not easy. It's never easy. I remember my first one. I remember my last one, and I remember every single one in between for 19 years. And so, it's difficult to put information like that in front of a jury because literally sometimes you can physically see them getting upset when they're looking at photographs and they're hearing you describe the things you have. Now, in this particular trial, we're at the stage where it's a sentencing phase. And so, the trial's all about fact and the sentencing phase is mostly about emotion. And so I think what the prosecution's trying to do here is really paint a picture of the horrific conditions inside that house and put the jury in the body of that victim that made that horrific 911 call that was so compelling, and realize that had she not made that call, she might have been another body in that closet. So, they're trying to strike an emotional chord with the jury by giving this graphically detailed testimony to show the horrific conditions and just a house of horrors that Great had created there. The same bindings that are on the mattresses are still on the bodies in the closet. So you can actually see his pattern. He would tie them to the bed, then he would, do what he was going to do. They'd rape and kill them and then take them out of there with the bindings still on them and put them in the closet and then put more bindings on the bed. So this is a horrific story, case. And they're trying to bring the jury into that house, into that closet, talking about the smell, talking about the state of decomposition, the maggots as opposed to the pupa. And so you're trying to really get a visceral reaction from this jury because you want to strike that emotional chord because they're about to determine whether or not they want to sentence this individual to death.
And I can't help but think the jury's listening to the jury heard that, and they can get a sense of what that crime scene looked like. Our viewers, our listeners, they can get a sense, we can get a sense, but there's nothing like the investigators, like Ed Staley, who actually went in there. And I'm sure there are crime scenes that stay with investigators for their entire lives, and I'm sure, Bobby, you could probably agree. We're going to take a quick break. When we come back, we're going to jump back into the Shaun Great case, and we're also waiting for our feed back in the Shaun Harrison case, this reverend who's on trial for attempted murder. There's a lot we're covering here on Law and Crime. Stay tuned. Back, everybody. So that's the case we're covering here, Shaun Harrison. I'm here with Bobby Chacon. Bobby, question for you. There's something that doesn't sit right with me in this case, and there might be a lot that doesn't sit right with me in this case. But one of the things is, and we've seen this before in other kinds of cases, if you're going to commit a murder and you're going to shoot someone in the back of the head, why do it in a public place? Why do it out in the open?
Yeah, that's a good question. I mean, that the answer is only going to be in the mind of the defendant in this case, if he in fact is guilty of doing just that. You know, there could have been a situation where he wasn't planning on killing him, but the way the conversation developed, he was going to read him the riot act. He was going to try to get him to up his game, sell him more weed, whatever it was. It may not have started out as that. You know, oftentimes when someone's being disciplined by even a legitimate boss or something, you know, they go in and they talk to them, and during the course of that conversation, things go in a different direction. And so I think you could have had a case where he didn't start out to kill him, and then the conversation went to that place. Although, you know, when I look at the video, it seems to be a pretty remote place. Now, there was a little bit of light, but, you know, you can see them walking alone. I don't see many other people, if any other people in that video. So it's hard to know the physical location where they are, whether it's a crowded place, whether they're near a place where other people would be.
Well, I think it was near a gas station. That's how it was captured on video surveillance footage, right?
Right. And there was a light that's kind of shining on them at one point. But, you know, I'd have to physically look at the entire surrounding area to see if this was a case where, you know, he kind of knew no one was around. Maybe he was familiar with that gas station. Maybe they had been there before. You know, there's a lot that goes into whether or not, you know, and then again, it's an opportunity thing. They were talking. The conversation might have gone in a different direction than he anticipated. And he says, "I've got to do this now," or whatever. I don't know. It's hard to say why he picked that spot. Again, that's only going to be, you know, in the mind of the person who actually pulled that trigger.
For anybody just joining us, we're going to be live again in this courtroom. This is the Shaun Harrison case, Reverend Shaun Harrison, who's on trial for several different crimes in connection with the attempted murder of this high school student. For all of our viewers, that's a live feed into the courtroom. The attorneys are having a conversation with the judge. We'll dip back in once we have that audio. That's also for our listeners as well. I wanted to ask one more question for Bobby, maybe two if he plays his cards right. Bobby, one question that I have for you right now is the details behind the shooting, like right before this happened, are a little murky to me. According to Rodriguez, Harrison tried to get another student to attack him shortly before this happened. Prosecutors allege that Rodriguez was attacked at English High School at Harrison's direction by the teen's longtime friend, Ludi Arias. And that's like a weird little detail in this case. I mean, you want to say he's a drug dealer, you want to say he's putting out hits now, and it just adds to this narrative. Is there any part of this that's a little too unbelievable to swallow?
Not to me. I mean, look, we've seen this before in different types of cases, mainly child sex predator cases, where somebody in the standing in relation to these children that they're manipulating, in this case, manipulating to sell drugs, stands in a position of trust, a teacher, a clergy, you know, another professional that is in somehow related to these children through a position of power and of trust. And so manipulating these children is part of the overall scheme. And so for him to use another student to attack this student, this person, young person that he's having problems with, is not beyond my belief that that's the way he was running his little kind of organization, to use these kids against each other, to rat each other out, to keep each other in line and that kind of thing, and then to keep his hands clean. Obviously, he probably, if he's been doing this a number of years, as alleged, then he probably doesn't want to do a lot of things himself directly because of the facade that he's using to shield himself from that criminal activity, the facade of being this paragon of virtue of being a mentor to these children and things. So using another child in this scheme to do some of his dirty work would be, I think, very consistent with the overall scheme of what he was trying to do.
And the prosecution has a great title to use. He was a reverend. He was a pastor. People wanted to believe in him. They trusted him. And so, as you said, that position of trust, the prosecution is really feeding into that. For all of our listeners on Sirius XM Radio, there is a live feed into the courtroom. I want to confirm if we have audio yet. And I believe the lead investigator is still on the stand. Bobby Chacon and I were talking about the idea that the prosecution is really trying to say that this whole case was not investigated properly. So as soon as we have that feed, we're going to make sure to go back into it about this lead investigator. And Bobby, that's really another key point in this case. We talked about it earlier. This is a classic example, right? Trying to attack the investigators here and say, why did you go after my client? Why did you go after this reverend? Why didn't you test this material? Why did you test this material? So it's a really, again, if you could, real quick, we have about like 20 seconds or so. What do you think about that strategy?
Well, I mean, it's one that you use when you don't have much else, and sometimes it's successful. So you have to explore it. I've been in that investigative situation. I've been the guy in that witness box who has to look like he's perfect. And a lot of times the prosecution will actually jump the gun a little bit and say, this isn't a perfect investigation. There are no perfect investigations, but here's what we know factually, and put it forward like that. So I've been in that situation. It's a difficult situation. The jury always wants everything perfect. The defense will make the smallest mistake look like it's significant, even when it's not. So, it's a tough position to be in, and I feel for that investigator that's on that witness stand right now.
Yeah, unbelievable. Bobby, stand by. Here, we're going to take a quick break. When we come back, we're going to be live in the Harrison courtroom. Stay tuned. We'll be back in a minute. Welcome back to the Law and Crime Network, everybody, and Law and Crime on Sirius XM Radio, channel 109. I'm Jesse Weber. Thanks for joining us. We are live right now in the Shaun Harrison case out of Massachusetts. A man who says he's a reverend, who claims to be a reverend, who's on trial for allegedly attempting to murder a high schooler by shooting him execution style in the back of the head. And what's the motive here? Well, the prosecution says that this Boston pastor is really leading a double life as a drug dealer. And he hired Mr. Rodriguez, or enlisted Mr. Rodriguez, to be his sales associate, to sell marijuana for him. A dispute erupted, and it was over apparently decreased weed sales, and he tried to take him out. We have a live feed. We're going to go live. I will be signing off. Heather Hansen will be signing in as your host that will take you through the rest of this testimony. Again, this is the Shaun Harrison case out of Massachusetts.